My name is Ron Drescher. I'm an attorney practicing bankruptcy and creditors' rights in Maryland, Delaware, Pennsylvania, and Virginia. And today I want to answer the question, my spouse is not filing Chapter 13 and her income should not be included in my calculation of what I'm supposed to pay to the Chapter 13 trustee. Is there anything I can do to make this less severe? The answer is yes. There's a very important thing in the Chapter 13 world called the marital deduction. And this happens when a spouse that is a wage earner does not file for Chapter 13 with the debtor spouse. And the non-filing spouse has expenses on their separate debt. Or if it's a second marriage, maybe his or her own children, or for their own car, or their own living expenses, or educational or recreational expenses. None of those type of expenses go towards contributing to the household and the upkeep of the debtor or a dependent of the debtor. And as long as money is being spent, or for that matter, saved, on something other than towards the upkeep of the debtor and the dependent of the debtor, then you can deduct that from what the non-debtor spouse earns to come up with a more realistic and really a more lenient figure for the debtor to determine how much they're going to pay on their Chapter 13 plan. The marital deduction is a very important part of Chapter 13 work and should absolutely be considered anytime a married person is going to file Chapter 13 without their spouse. My name is Ron Drescher. I'm an attorney practicing bankruptcy and creditors' rights. And if you have a question about how much your marital deduction should be, please pick up the phone and call me. I would love to hear from you.